So force majeure issues. When you go to analyze the force majeure clause in your contract, you need to ask yourself three main questions, three central issues that need to be resolved before you can get a clear analysis of whether you have relief under the force majeure clause or not. So the first question is, does the force majeure clause apply to the facts of my company's situation? So the facts that are rising to your difficulty in performing, or possibly could give rise to the difficulty to perform. The second clause is, if the clause applies, is my performance excused? So there's different standards, as I mentioned. Sometimes it has to be prevented, sometimes it has to be overly burdensome, and we'll get into that. And the third question you have to ask yourself is, if my performance is excused, how do I invoke the force majeure? So for the purposes of presentation, we'll assume that our force majeure clauses, the sample clause that we looked at previously, will be governed by Texas law. So how does the force majeure clause apply to my situation? So under Texas law, there is no boilerplate language that will serve as a catch-all. So there's no standard language you could include in a contract, in an MSA, that's going to encompass every single situation that could give rise to a difficulty or impossibility of performance. Texas courts, when they analyze these contracts, when they analyze these clauses, they're going to examine the contract's language specifically to determine the scope and application. First, they're going to look to the events specifically enumerated in the force majeure clause. So that'll be things like fires, floods, acts of God, hurricanes, tornadoes, governmental orders, insurrections, all the things that you've probably seen before to one extent or another in most force majeure clauses. So examining further the question, does the force majeure clause apply to my situation? So in the context of the coronavirus pandemic, the applicable language, if you have it in your clause, might be pandemic, pathogen, outbreak of disease. That's going to be a pretty concrete argument that the current situation applies, undoubtedly. Unfortunately, we haven't seen so far many of these clauses. It's likely that we're going to start seeing them from here on out, but so far, in most oilfield services MSAs, you don't see this kind of language in the force majeure clause. Potentially applicable language would be act of God or governmental or regulatory orders or acts. So, and I think to keep in mind is, as a general rule when evaluating your specific language, is that more specific the language is, the more likely that a court will find the force majeure clause to apply. So the thing to draw from this is, unless your force majeure clause mentions pandemic, coronavirus, or something like that very specifically, your next best bet will be to rely on act of God or acts of government or something along those lines. So generally in Texas courts have found that an act of God, as that term is often used in force majeure clauses, refers to natural forces, events, or costs. So things like tornadoes, hurricanes, severe storms, floods, things of that nature. It generally excludes, and it generally means events without human intervention, such as hurricanes and floods, and things like that, natural storms, as I mentioned. So it would have to preclude something where there would be human intervention. Consequently, it's not clear whether the current pandemic would qualify as an act of God. As I said, there's a good argument to be made if you don't have anything more specific to argue in terms of language in your force majeure clause. But there's also some counter arguments, like that the government intervention in response to the coronavirus pandemic is actually the factor which renders the performance impossible or difficult. And therefore, under Texas case law, it's not an act of God. So that might be a counter argument you would see from the other side if you ever had to litigate this. In addition to specifically listed events, a lot of force majeure clauses will include what attorneys believe, the drafting attorney believes, is catch-all language, although we said that that doesn't really exist under current Texas law. And this catch-all language is often thought, or is hoped that it will include all other unspecified events. So we can see the example from our sample force majeure clause on slide 12. Any other similar causes that are not reasonably within the control of the party so affected. So that would be an example of catch-all language. Unfortunately, what often happens when these force majeure clauses have been litigated is that the courts have found that that kind of language raises contract interpretation issues. And the way that courts have dealt with them is through applying a doctrine called justum generis. And so basically what that doctrine says is if the catch-all language comes after the specific enumerated list of events, like it does in our example, then the court will apply that doctrine, and it will mean that the catch-all cannot extend to events that are significantly different than the enumerated events. So the situation, if you had a force majeure clause that for some reason only described natural occurrences like storms, hurricanes, floods, whatever, and then you had a catch-all language similar to the one in the slide here at the end of it, a court would likely find that a pandemic or coronavirus would not be included under that catch-all language, that the catch-all language would only intend to include other types of natural occurrences that were not specifically enumerated. And so that's a thing to watch out for. And if you have an opportunity to renegotiate that, and if that language is in a force majeure provision, try and see if you can just move the language around to include it at the beginning of any list, including but not limited to, or something along those lines. Additionally, in Texas, the catch-all provisions can only apply to events that are unforeseeable. So this may not be the case depending on your specific language in the contract. So the second analysis is, well, if the clause applies, is my performance excused? And this, you will have to refer to the specific language of your force majeure clause. So the standard by which your inability to perform is measured will likely be described in the provision itself. So the first part of that is what standard applies to your inability to perform. If your specific language in the force majeure clause says it has to make it impossible or illegal for you to perform, then that's the standard. If you can still somehow perform, or if it's not illegal but extremely burdensome or difficult for you, you're likely not going to have relief under that force majeure clause. Or sometimes it may say only difficult or delayed, for example. Well, that's a bit of an easier standard, a broader scope of situations. So if your situation meets the standard in the provision, what does the provision exclude? Typically, the force majeure provisions will only excuse delayed performance during the period of the delay that is caused by the force majeure event. And sometimes they'll have additional language saying, if you have the ability to find a reasonable workaround, then you have to try and continue your performance under the contract. And usually there's also a time limitation on how long work or performance can be stopped or delayed, even under a force majeure event, before the other party gets to exit out of the contract or terminate the contract or seek some other kind of relief. So the last part of the analysis is, if my performance is excused, how do I invoke force majeure? And again, you'll have to refer to the specific language in your force majeure clause that you're evaluating. And so typically, there will be some kind of description of notice requirements, and maybe even a time constraint on how soon after you're aware of a force majeure clause or force majeure event, occurring that would apply to you. You have to provide a notice within a certain number of days. And sometimes the clause will go so far as to even describe the means or the method by which you have to provide that notice, whether it's by email, whether it's by certified mail, or career, likely not going to see that, but just some examples. And so you have to make sure that you go back and you read very carefully your force majeure clause and understand what the notice requirements are, because Texas courts have interpreted these pretty strictly. If the notice requirements and the force majeure clause aren't complied with, no matter how burdensome, then you will likely not be able to obtain relief under the force majeure clause. So that finishes out our analysis of how to look at your force majeure clause, you know, in kind of at a general 101 level, and get an idea of whether it may be applicable to you. We had touched earlier on about this unprecedented situation, you know, with the oil price war between Saudi Arabia and Russia, situation with OPEC, you know, the coronavirus pandemic, the collapse in demand, all of those unprecedented factors that have come together all at one time. And so, although this may not be applicable to you specifically as an oilfield services company in a direct manner, I wanted to touch on an interesting point that maybe some people have thought about, and it's that, well, you know, what about if the oil market just climbed, the price of oil has gone negative? I mean, that's never happened before. Would that provide us maybe some relief? Could we reach for that if we needed it? And the answer is not 100% certain, but there's some interesting case law out there that's touched on this in the past, and I wanted to give you a couple of examples here. From federal courts and federal circuit courts, this is where this has been held mostly, is that drastic fluctuations in oil and gas prices have been held to not constitute force majeure events unless they've been described specifically or enumerated specifically in the force majeure clause at issue, which they rarely are for understandable reasons. In one case in particular, court held that Saudi Arabia's attempted market manipulations did not constitute a force majeure under a catch-all provision. So that is an interesting piece of case law out there, and it might be indicative of how courts will rule in the future if these issues come up for litigation again, and if the situation continues or hopefully not, gets worse. So like I said, I'm going to put my email address up here. We're not going to have a Q&A session today, but I would appreciate if any of you have any comments or questions for me about any part of the presentation, or even anything related to master service agreements or other types of contracts. Please feel free to shoot me an email at this address, and I would be happy to correspond with you or get with you on the phone. All right, well, y'all stay safe out there and take care, and thank you for listening in today.